So what's the difference between a will and a revocable living trust? Some people are told they need a will. Some people are told they need a trust. And if you make a mistake and you don't pick the right one, you could be costing your family thousands of dollars in court fees or potentially setting them up for an elongated fight about who's right and who's wrong. My name's JP Rankin. I'm an estate planning attorney licensed in South Carolina, North Carolina, and California. I've helped hundreds of families avoid probate, create an estate plan, and a legacy that they're proud of and they know will work when they need it to the most. In this video, I'm going to go through the differences between a will and a trust and why one may be better than the other given your particular scenario. So let's start with a will, your last will and testament. There are some very important and necessary pieces of this document, this 12-page document that's going to be on a specific weight paper according to whatever county you're probating it in, and they all have different regulations, but there are a lot of things that are important that you need to make sure that are in there. But what a will can do is provide a public written document that appoints an executor in North Carolina and South Carolina. That's a personal representative. So it appoints an executor. That person is going to do what the will tells them to do, and it's going to distribute all of your assets in accordance with the terms of what you've written in that last will and testament. If you've got minor children, it's going to determine guardianship of those children. And unfortunately, if you've got a last will and testament, it's going to ensure that your loved ones are going through probate court. Depending on what state you're in, you may have a very long, drawn-out, expensive probate court proceeding, or you may have a more truncated proceeding that's even more expensive. South Carolina, there's an 8-month minimum creditor claims period, which means when you pass away, if you have simply a will, your personal representative is going to file a public notice that you've passed away. And then your creditors have 8 months to make claims on all your outstanding debts. So medical bills, credit card bills, whatever you've got outstanding on your car, boat, or RV. Creditors are going to make claims on all those things so they can make sure that once that period is finished, your personal representative is going to pay all those outstanding debts. And then according to what your will says, if you had 2 independent witnesses and it was notarized in an official capacity, then it is a legally binding document. The probate court will audit that will, and after the creditor claims period is finished, your personal representative can begin doing what the will instructs them to do. So sell the house and give the proceeds to my 3 children, etc. That's what the personal representative does. And in South Carolina, it's anywhere from 4 to 6 months after that minimum creditor claim period has closed. All the while, you've got probate court fees, and if you hire an attorney, which you definitely should, you're going to have attorney's fees, court filing fees, etc. So those are all of the things that a will can do. And although you may be looking here and see in my very perfect handwriting that it can create a testamentary trust, which a will can do, but testamentary means after you've passed away. So you go through the whole entire probate court process, and then according to what the will says, you may then create a trust after the probate court proceeding is finished. Some people prefer that. I personally don't have any good reason why anyone would want that unless they want a court and a judge to oversee the proceeding because they've got family that they know are going to fight and they know need supervision. But when I have those sorts of situations, I always recommend a revocable living trust because then there's no court to even hear those claims. There's nobody to even listen to those arguments, which we all know sometimes with our family members can kind of be asinine. So we've previously gone over what a will is and all the formalities required in that document. Now we're going to discuss a revocable living trust and why you might need one. So your revocable living trust, it's a contract. It's basically a stack of papers until you fund it, you witness, you notarize it, and you execute it. So we're going to draw this as this is your revocable living trust. This is your papers. This is your contract between you, the grantor, the trustees, and the beneficiaries. A revocable living trust is private, so no court, no probate court, okay? It holds all of your assets, and it allows for your successor trustees to instantly own everything that has been properly funded into that trust. So, JP, you may be asking, what goes into the trust and how do we do that? So what we take is your house, right here. And a little door, 2 windows, like so. Okay, we take this house and we fund it into the trust. So we deed over the property to the trust. So your real property is owned by the trust. Then we take all of your bank accounts, your IRAs, your 401ks. These are all going to be their own documents. And we change the beneficiary designations to go into the trust. They're going to be in the name of the trust, okay? So now we've taken care of real property, your intangible personal property, which is your bank account, your 401k, your IRAs. And then we're going to take all of your tangible personal property, so your jewelry. This is a wedding ring right here. I know that you knew that because it obviously looks like a wedding ring. And we're going to assign the tangible personal property to the trust. Okay, so now real property, tangible personal property, intangible personal property are all funded to the trust. Okay, you pass away. Your successor trustee is going to take all of these assets and they're going to distribute them in the name of the trust in the way that you have created in the trust, in the language of the trust. So you have 3 children and all 3 of them are going to get their own descendants separate trust. So it's like this. So now you've got 3 separate trusts for all 3 children that are run by the successor trustee, okay? And that can be anyone that you choose. But the important thing is to honor the word in its use. You have to trust that person because what they're going to be doing is distributing all of the assets in accordance with the revocable living trust. So they have to follow your instructions. They don't need to be a CPA. They don't need to be a realtor. They can hire those third-party experts, but you want them to follow your instructions. So you have to trust that person to do so. And then you can set these separate trusts up however you want. You can have ages and stages if you want. You can have it be as creative as you want, but the beneficiaries will receive the assets in accordance with the trust that you have created when you create this revocable living trust. So trust, private, nearly immediate, and virtually inexpensive on the back end. A will, public, expensive, drawn out. Now that you know a little bit about estate planning, wills, and trusts, which one do you need? Unfortunately, I won't know until you come in here and talk to me. So we've got a little link below, book a consultation, get in touch with us, and I'd be more than happy to discuss what's the best for your family and your needs.